the shuttles and make dinner. I know everybody's looking forward to dinner, so we'll go ahead and get started. My name is Christie Matthews. I'm from Charlotte School of Law. I'm very happy to be moderating our panel on justice and contract avoidance. I'll introduce our panelists, our presenters, and then we'll give them time to present. They'll each have roughly about 20 minutes to present, and then I'll open it up for questions. Our first presenter is Babette Boliek from Pepperdine University School of Law, where she's an associate professor. She teaches contracts, antitrust, and corporations law. And she is going to be presenting on coercion by contract. Our second presenter is Gerrit Geest. He is the James Carr Professor of Law at Washington University School of Law and is currently a researcher at Coercion Institute for Law and Economics at the University of Chicago. He's going to be presenting on the death of caveat emptor. And then lastly, we have Joasia Luzak from University of Amsterdam. She is an assistant professor at the Center for the Study of European Contract Law Research Institute at the University of Amsterdam. She teaches contract law, Dutch contract law, European consumer law, private law, among other subjects. Her presentation topic is To Withdraw or Not to Withdraw, Evolution of the Mandatory Right of Withdrawal in Consumer Distance Selling Contracts. So first we'll hear from Professor Boliek.
Oh, I just brought my microphone with me. Oh, welcome. It looks like we have a lot of students here. Do we have students here? Oh, that's awesome. I have good news and good news for you. The good news is, and don't take this the wrong way if you're one of these people, but I am not a contract scholar. What does that mean is that this is going to be more, less a fait accompli than a work in progress. I'm going to be thinking about some issues and questions that have inspired me to think like a person. That said, I teach contract law. I call it Learning Contracts with Boliek. I just don't think my students realize what I mean by that. So to put into context, I'm with the students on this one. We're about the same level, and I'm trying to think through some issues. And let me start about where we're going to go. Coercion by contract is sort of the title, but I was inspired by a particular contract that looked strange to me on many different levels. Now, as mentioned, I teach antitrust. I do have a PhD in economics as well as a law degree, which makes me doubly alienatable at cocktail parties. But that said, that's the background I come from. A lot of mergers. I do communications law, telecommunications. I deal with the internet and exciting things like that. So I'm dealing with licensing of the spectrum. So anyone here have a cell phone? Good. You see, they always say relate to your audience. So well done. Okay. Do you have a phone by this person by chance? By Verizon? Anyone? You didn't see it there. That's Verizon. Oh, right. Two? Really? Just two? It's the #1 carrier in the world. People rethink your contract. But anyway, so Verizon Wireless actually got a license. And in the license, which the FCC gave them, there was this language, if you can see it: licensees shall not deny, limit, or restrict the ability of their customers to use the devices and applications of their choice on the licensee block network. Now, we're going to find out that actually it was viewed that they did not abide to this. What was termed in the enforcement that preceded them not abiding to this as a violation of a voluntary condition. Well, I saw the word shall, and I saw voluntary condition, and I was confused. So it bothered me. Why do we have this term voluntary condition, that sounded very contracty to me, being an expert in the field. So I then went to other areas too, and I had another area, again in telecom, which is kind of my space, and MCI WorldCom, and they had a merger. And in the merger was this language that MCI WorldCom agrees to fire employees the first time an employee uses profanity during a sales call or harasses a customer. That's in the merger agreement. And it is called a voluntary commitment. Again, it sounds like they're using contract law to do something different than their regulatory role provides. And indeed, when we go through it, I'm going to say that's exactly what they're trying to do, and there's problems with this. You have this extensive use of the voluntary commitments, voluntary conditions or standards, and consent decrees. So my first question is very basic. Are these contracts the way that we're teaching our 1Ls about contract, which is usually thought of as private ordering? Here we have an agency, or agencies as it turns out, on one side of the deal. Does that change it? Does that change our analysis? If it's not exactly like the kind of contracts that we're looking at in our 1L year, is there something that contract law can do to help frame the issues that might arise out of this? And so thinking about this a little bit, first of all, it is in the regulatory field. And in this regulatory field, consent decrees are actually pretty cool for speed. They're very fast. They cut through a lot of issues, and actually the regulated love it at times. And the regulator does as well. So there's this speed and efficiency in certain issues that it would be great to get a voluntary commitment and not deal with it. It's almost like putting the remedy right into the commitment. But then the question comes also too about agency overreach. Are they trying to do by private contract, or what kind pseudo-private contract, what they can't do otherwise? So in this question, you have efficiency, this use of voluntary agreements, and believe me, the regulated industry sometimes likes it. In fact, in our current merger atmosphere, Comcast, who wants to join with Time Warner Cable, is using as a point of pride that they are under a consent decree. So everything you worry, don't worry, because we're already under a consent decree. So it can be used very effectively by the private industry. But then there's this overreach question, is voluntary agreement being used to circumvent democratic processes? Are we trying to do by contract which we can't do under our jurisdiction? And quite frankly, I'm going to just tell you the answer is yes. Absolutely. There's no question that certain things that the FCC has asked for are absolutely outside of their jurisdiction. One of the examples I just gave you is in the merger deal. That was an FCC condition about when you have to fire an employee. There's no authority to do that. That would be a labor, the Division of Labor to look at something like that. And there are other examples. So yes, they're doing that, but I'm wondering if that's my primary point right here. I think rather I'm wondering what contract law can add to this conversation. Either why it would be a good fit for analyzing these, would be able to control agencies or help efficiency, or is able to tell us a different story, help explain why we should be concerned about these types of voluntary agreements. So to put aside what I don't want to talk about today, there are Administrative Procedure Act controls for regulated industry that basically says you have to go through a rulemaking proceeding. It has to you have to have jurisdiction to do the things that you are required to do. These type of agreements, these voluntary agreements, put the action outside of the APA. So they are just not under those controls. There is also this thing that comes in and out of vogue, apparently, unconstitutional conditions doctrine. Arguably, you can't require that you waive a constitutional right in order to get a government benefit. For example, give up freedom of speech in order to get a waiver. I don't want to talk about that today either, whether or not it's popular. As Kathleen Sullivan, in one of the most cited papers about this, talks about, is that there are issues there that if you're pressuring conditions of government, what you're doing is changing sort of the power between government and right holders. So what I want to talk about more is what can contract law tell us about this? What sort of issues or language might we talk and think about these things? And kind of leading off of what Kathleen said is the first thing you think about is sort of the beginning of any contract, this assent and unequal bargaining power. And I'm so glad that, and then other things that I'm thinking about too that seem to come into mind when you're dealing with a government who is able literally to give you the one input that you need to do your business or not, that you're thinking about maybe duress or economic duress specifically. And what about unconscionability? Are these even viable to talk about in these contexts? So first, getting to assent and bargaining power, sort of thinking about, we talk about voluntary. This is all premise that it's voluntary. That's what removes it from the judicial review that it would normally get under rulemaking. So what makes voluntary, and what does that mean in contract law? And I'm so glad you're here, Dan, because I need to quote you, paraphrasing from this morning. Contract, even of adhesion, are normatively justified by assent. I love that quote, Dan. That was really good. But Dan has written a lot on this issue, so I'm eager to hear what he thinks about this. Are we talking about here? Are the entire premise of why we're removing it from judicial review is arguably because it's voluntary, that there's some kind of assent, but can we really talk about assent without talking about bargaining power in this context? And when we're looking at bargaining power, are we really looking, again, from that same talk, are we looking at, does Time Warner or Comcast or any one of these companies, Verizon, do they have a viable alternative? The FCC has complete control over the licenses. They need the licenses in order to have their business. It puts the government in a very unique sort of relationship to the regulated in this. And there are no alternatives. There are no alternatives except go through government approval. Negotiability, how we talk about these agreements are always referred to as being negotiated agreements, but is that true in this case? How much negotiation actually can go on in these instances? And how important are the characteristics of the party that it's actually the government or the regulator with the large corporation? So again, economic duress, is this generally something different than coercion? Again, is it because of the impropriety of the alternative presented that is the pressure used that is creating economic duress here? There really is no alternative here. Is that sufficient to talk about duress in these instances? Has there been found in dealings with government officials in the past that this construct of contract has been found, that the all or nothing of the state is different than the all or nothing of a private actor. And some courts have even looked at whether or not this victim of duress has protested, and we have ample evidence in these voluntary agreements that the victim, or one of the parties, if you would, has indeed protested to what is being asked of them. And then unconscionability, I'm not even sure if this would apply in this. I mean, it goes back a long time. We have seen it. It's not a doctrine used very effectively in policing contracts. But it would need something more arguably than just the superior bargaining power that we're seeing here, maybe unfair surprise, conspicuousness, the absence of negotiation, custom trade usage. All of these textbook sort of questions about unconscionability really don't apply to this context. The parties do know what's coming down the pike. So let's go back to my example and talking about these examples and seeing if contract applies in this. Again, the first thing was the licenses shall not deny, putting another application. Well, let me tell you what happened. This applied to only a few licenses in the Verizon family. Verizon is a nationwide company, and a few licenses were bought with this voluntary condition within it. Well, what happened is the ingenuity of apps makers. What the app maker did is make an app that allowed access not from one device, but as many devices as you want. Well, Verizon has a policy of saying, well, you can have maybe 2 devices with one connection, but if you want more than that, you have to pay us a $10 to $20 additional monthly charge. Well, this app bypassed that. And so Verizon asked for it to be removed from the Google App Store. Well, that was seen as a violation of this voluntary condition. The arbiter of that was the FCC. There wasn't judicial review of it. And again, a voluntary commitment came from Verizon when faced with the possibility of having licenses revoked. So the voluntary commitment was to allow this app to be on the store, arguably only for these licenses, no other of their licenses, and they paid a $1 million fee to the Treasury. So that's what happened there, and now they're under a consent decree that says they are not to take off that device. This, just so you know, is outside of the jurisdiction of the FCC. They are not permitted to just list, if they did it by general rulemaking, they can't list the things that you can and cannot have in the App Store. So this was a stretch for them, and if it was in a regular rulemaking, would not have been allowed. Why do we know that? Because similar provisions were knocked down by the DC Circuit not once but twice. So we do have good faith that this would not have been allowed in regular rulemaking, but is allowed through this more shadow type of process. Let me give you a couple more examples to see if you can help me flesh this out. Another one is that TMI and SECCOM agreed to furnish recent employment and residence history and biographical information of persons who occupy sensitive work positions and make employees available for FBI or Department of Justice interviews. That's the FCC putting that in the merger agreement under a voluntary commitment. That's not permitted under the FCC statute. So this was the way of the executive branch coming in and getting what they wanted through a voluntary agreement by requesting the FCC's assistance with that. So another example comes from Quest. Quest is they had to issue ads and brochures in language of customers' preference without any definition of what that meant. Here's Quest, here's Coerced, another way of advertising it. And the biggest way of advertising it is, yes, the Quest, but soon to be changed Stadium for all you Broncos fans out there. Again, the FCC is asking something very particular that they couldn't have gotten otherwise. And then one thing that people talk about a lot, you always try and get a chance to put something like that on the board. But is this Comcast, NBC, Universal? FCC put a lot of voluntary agreements in that one. And one of them was everything, if it was breached, had to go to arbitration. Again, no judicial review, even in the private contract context. So again, removing all this into sort of a shadow world. So the question is, if to the extent we think this is a problem, using private contract to sort of hide things from the process, the legislative process, we could ban all voluntary conditions. And in fact, that has been proposed by former FCC Commissioner Baker. Just do away with the FCC doing this kind of private side agreements. The other thing we could do is ban all waivers of judicial review, perhaps. Don't let them at least put that provision in there. So it gets into the courts somehow, either through private contract or through APA review. And maybe we do something, we ban or waiver judicial review, plus adjust private contract law to deal with the fact that there is a difference in character of the parties here. One is the government. That's with the true monopoly power. And maybe there's something else. Something else I'd love to hear from you after today. So thank you for thinking with me, and I look forward to the other talks.
Okay, my talk is about caveat emptor, the rule that says that buyers should beware. You hear sometimes this word in the political conversation, and so I'm going to make 2 points here. My first point is actually that caveat emptor is no longer a principle of the law. Although sometimes it is presented like this. If you open a Hornbook, you may see that in principle you don't have to disclose information. In principle, you can keep information for yourself, use strategically, but there are exceptions. And I will say that this is actually a misleading way of presenting the law. Actually, the law is so that it has now been replaced by the least cost information gather principle. So I'm going to say that caveat emptor is no longer a principle in contract law. It is an exception under very narrow conditions. But second, I'm going to solve a puzzle, and that is that in practice, buyers, consumers experience caveat emptor. If you've ever tried to buy a car, then you have the impression that it's a wild world out there. If you go to Best Buy and you get information, you don't know whether you can trust this advisor, whether it's biased, whether they want to steer you towards high-margin products, and so on. And I'm going to solve this puzzle by saying, indeed, that there are many cases where the least cost information gatherer principle is violated. So basically, I'm going to say, in practice, there is a lot of caveat emptor, but it's basically due by courts misapplying their own principles. And so my talk is so that I will explain general principles. I will derive some mid-level principles of it, and then I'll come to implications, and many of these implications may be controversial. So for instance, I will argue that in the current system, sellers give little information about quality. It seems to be up to consumers to figure out how good a product is. And that this is not only inefficient, it violates a fundamental principle of the law that says that the least cost information should give information. Many sellers, I use seller in a broad sense, don't publish their prices. If you ever have been looking for a plumber and you want to figure out who is cheap and more expensive, you would hope that they would all publish their prices on the internet, including of spare components. Nobody does this. I say that this should no longer be tolerated because it violates a principle that you see elsewhere in the law. Insurers do not reveal the actuarial cost of insurance or warranty. Sellers do not reveal the fact that maybe 20% goes back to consumers and 80% is markup. I say that this is actually a principle of rules that are principle, a violation of principles, and so on. I will actually, this is a byproduct of a book-length project where I look at marketing techniques and pricing techniques, and they all come down to finding cracks in the legal system, exploiting information asymmetries, setting up some traps, and they are tolerated by the legal system. So I will make a normative and a positive statement. Basically, what I propose is fundamental changes in marketing and selling methods So that's normative. So that's a change. So that's different than what courts now do. Courts tolerate this. But I say courts, it's not so spectacular. It's just a consistent application of the principles that we have in contract law in general. Now, let me explain. Yeah, caveat emptor is a principle that says buyers have to beware. If you translate it technically, the principle actually means there is no such a doctrine as misrepresentation. So in the extreme form of caveat emptor, sellers can just misrepresent, and there are 0 duties to disclose. It is an undesirable rule. It's not only unfair, it's definitely economically inefficient. This may be clear if you take a look at the extreme form of caveat emptor. Suppose that I make a painting myself, and I'm not a good painter, the market value is maybe $100. But suppose that I tell to you that it's a genuine, authentic Picasso, and you believe that, and you pay me $10 million. So you're $10 million poorer, and I'm $10 million wealthier. Now you could say this is plain fraud. That's not legal. It's not legal, it's plain fraud. But a pure caveat emptor regime would allow that. That would say, it's caveat emptor, buyer beware. It's your responsibility as a buyer to figure out that actually my painting was not a genuine Picasso. So you could ask, why would legal systems ever tolerate caveat emptor? And one answer is legal systems typically do not tolerate extreme forms. And over time, they develop more and more rules and texts of caveat emptor. Now the question is, why don't they, from the beginning, go to the extreme? Well, that's for the same reason as why old legal systems with a limited capacity, why they tolerate some bad social behavior, because their capacity is limited. So Roman law had some rules on fraud, warranty. And in the 20th century, it has been extended, the attack on caveat emptor. Fraudulent misrepresentation became negligent misrepresentation, and then concealment was attacked, and then half-truth, and so on. You go to 1L courses, and you see that more and more exceptions have been formulated in the 20th century. Now, it does not explain the law very well. And what explains the law better? It is this principle of Kroneman, the least cost information gatherer. 1978, that's after the restatement second. So in many books you don't find least cost information gatherer because the books look at the language that you can find in the restatement. And so in books and also bar exams, they only check legal insights that were developed before 1970. So this is 78. But it actually basically says that if you have an information problem, you should ask who's in the best position to produce information. So who's the least cost information gatherer? So the standard example of Kroneman was a seller of a house infested with termites. Is this socially valuable information? Yeah, that's the information we'd like to know. Who's in the best position? Well, the seller. The seller knows that as a byproduct of just living in the house, the buyer can figure it out. If you pay inspection report, you'll figure it out. But that's a waste. Kroneman said the least cost information gatherer is the seller. And so that's why the law obliges, or most states actually oblige, sellers to reveal that. Now, it's a general principle. If you ask, for instance, side effect of drugs, is that the responsibility of consumers to figure that out, or of pharmaceutical companies? Well, who's the least cost information gatherer? Who's in the best position to produce that? Well, pharmaceutical companies, they have economies of scale. I, as a consumer, I have no economies of scale, so it's clearly they are in the best position. But you see, informed consent is basically that. The doctor knows more about safety risks, so the doctor has to reveal it to me. The doctor is the least cost information gatherer. In products liability, producers know more about safety risks, so they have to produce information and reveal it, and so on and so on. If you look at the details of contract law, you basically see that this is also what general contract law applies. Sometimes under other headings, if you look at opinion rules, sometimes you can rely on an opinion, sometimes not. You can rely on it when it comes from an expert. That is when that other person was the least cost information gatherer. You cannot rely on it if you had more information or nobody was the expert. So if you go also through general contract law, you see this is the general principle, actually. Now, this principle is so logical that the exceptions must be carefully defined. It's very logical because you could say it's a more general principle in the law. In tort law, you see something similar, least cost avoider. Two people can prevent an accident which party should do it, which can do it at less cost. Now, what are the exceptions when the least cost information gatherer should not be applied? One was identified by Kroonman, and that is entrepreneurial information. So when I do research on your land and I discover there are mineral deposits, I don't have to tell you that, although I may be the least cost information gatherer, because if I would have to tell you, I have no longer an incentive to produce that information. So here we want to protect the production of certain information, but it is a narrow exception because we violate a principle that has a strong justification. And there can be a couple of others. Sometimes markets work better with less information. That's not the standard way, and usually information leads to better markets, but there are exceptional cases. Sometimes insurance markets work better if insurers do not know certain information about preconditions. And but these are narrowly defined exceptions. Non-falsifiability is not really an exception, that's just a practical barrier. Now, from these, I derive some mid-level principles. And these principles are actually in the law. And sometimes they are formulated and sometimes not. In a sense, they are obvious, but because they are not always formulated, I formulate them. One is, and that may take a minute to explain, the difference between the absolute least cost information gatherer and the relative least cost information gatherer. That is, the question, when should I disclose and when should I not disclose, but I don't have the right to misrepresent. So if I sell Apple iPads, do I have to disclose that I know that Google has some good products or so? And the answer is no. But if I tell you wrong statements about Google, can you rely on that? And the answer is yes, because I'm the seller, I'm the expert, and you're inclined to believe because now if you analyze it, the absolute least cost information gatherer, that's a person who's in the whole society in the best position to produce information. The least cost information gatherer is the one of the two parties. So Apple, they are the absolute least cost information gatherer with respect to their own products. They're in the best position to acquire information on their own products. Who is the best party for Google? Well, Google. So Apple is not the absolute least cost information gatherer for competing products, and so they have no duty to disclose. But they are the relative least cost information gatherer compared to me, who knows nothing about computers, and them, they know more. So if they make a statement, I'm going to believe them because they are the experts. And so this is a principle that is not identified before, but which explains the difference between duties to disclose and just no rights to misrepresent. A second point here is materiality. Now, materiality is a general principle of contract law. You have learned that in 1L, definitely. My point here is that courts make errors. So basically, materiality means information is important enough to be produced or to be precise. So the costs are lower, the benefits are higher. But courts, in practice, they err a lot by not considering search processes. Yeah. In practice, and here is the thing, very often a search process is sequential. Let me maybe give you an example. Should I reveal markups? Should I reveal the fact that my markup is low or high? Well, in an ideal search process, that's not relevant. So in an ideal search process, I see all the products and their objective characteristics, and I see that one product has a certain quality and it costed 100. Now, why that cost 100? Whether the markup is high or the production cost, it's not material. So courts are right to say that you should never disclose markups because it is not material in an ideal search process. However, in practice, many search processes are sequential. It is described by Stigler, Nobel Prize winner Stigler. So you go to one shop and you hear information about one product. And then you can decide to stop your search process and decide. Or you can go to a second, which is costly. And after the second, you can decide to choose one of the two, or you can go a step further. Now, in such a search process, salespeople will try to mislead you in such a way that you stop searching. So a salesperson wants you to stop searching. Look no further. And they may mislead you. And they may mislead you, for instance, about markups. Maybe you pay a very high markup, but they will say, hey, my markups here are exceptionally low. And if you believe that, you stop searching because the chance that you'll find a better product for a better price. No? So here markup, misrepresentation can become material. And many other examples of look no further stories are tolerated by courts because they don't realize that it's material in this search process. Efficient disclosure is another. To the extent that you have to disclose it in the most efficient way. Now, let's take a look at market practices. So I have a whole list of practices that actually violate this. One is that, as I said, you want to have information about the quality, like a vacuum cleaner. How often does it break down? What's the quality? Now, we ask the question, who's the least cost information gatherer? Well, the producer is in the best position to obtain information. As a matter of fact, they obtain information as a byproduct of selling it. They see the number of complaints and the spare components. So they should reveal what they know about the reliability and honestly reveal that. What you see in the market now is that they don't say anything, and then consumers or consumer organizations have to kind of reverse engineer the information that's already on a hard disk by a manufacturer. Now, this violates the least cost information gatherer. And so I say courts should not tolerate this. If they tolerate it, they're inconsistent with the termite cases. Not publishing information is price information. Plumbers don't publish their prices on the internet. Is price material? Yes, it's a material element. That's an important thing to know in your decision. Who's the least cost information gatherer? Well, actually, the plumber has all the price lists. Then what is the most efficient way of communicating this price? Is it inviting someone for a sales talk and then after half an hour revealing it? No, the most efficient way is to put it on the internet. So if you put all the things together, it suggests that sellers and service providers should publish their full price list, which is somewhere on a hard drive on the internet. That is the consistent application of here. Another is warranties. There is strong evidence that extended warranties are full of markups. There's a strong documentation in the marketing literature, also in the economic literature. An estimate is that on average the markups are 80%. Now, so it's basically a market failure. As a matter of fact, it becomes irrational to buy extended warranties because it's a low amount, and it's only rational to buy warranties if actually what you get back is high and so on. Now, we want this information. So is this material information if you buy a warranty product? So what is the statistical chance that it will break down? And so how much do you get? Yeah, it's material. So who's in the best position? Is it Best Buy or is it you? Well, Best Buy, they are in the best position to know it. So they should reveal it. So when Best Buy said, you want to buy a warranty here, it costs only $159, then they should reveal, hey, 80% is a markup. You only statistically get back 20%. That is an application of the least cost information gatherer that we apply. Then you have more subtle marketing forms. One is that many marketing techniques come down to deliberately making products incomparable. And you have a product, and you're going to sell it in 2 supermarkets, but then there can be price competition. So they complain, and you know what? You sell them to the 2, but in a different, you give a different brand name, and the design is slightly different. And now consumers can no longer compare. So, but it's a deliberate strategy. And in this sense, if you apply principles of contract law, you'll see deliberate, it's misleading consumers, it's deliberate, it's concealment, it's actually, it falls under the definition of fraud. Put it this way, if there are 2 products of a different brand, the consumer should have information about the relative quality, and if they are more or less the same, consumers should know it. Who's the least cost information gatherer? Well, the one who produces that. So it should be revealed so those strategies, in essence, are forms of creating errors, and they should also no longer be tolerated. Another is false differentiation claims. There is a recent study by business economists, and actually economists of the business school in Chicago and University of Amsterdam, about generic drugs. Bayer aspirins cost 3 times more than generic. And they study who buys then who pays the premium price, not doctors. So doctors, they buy the generics. Pharmacists for themselves buy the generic. nurses buy the generic. And so the suggestion is that the only reason why people do not buy the generic version is just a mistake, uninformed people. Now, Bayer actually tries hard to make a false differentiation claim. In the 1980s, they made publicity that they had the world's best aspirin that was tolerated by the FTC. But now they know that that consumers have a different view. Some consumers think it's different, and they try hard to make consumers believe that their aspirins are actually different. And so basically, they deliberately mislead by making a false differentiation claim. They say, or they suggest that their product is different, but it's not. So you apply the general principles of contract law, this should no longer be tolerated. Here is maybe, given time constraint, misrepresenting the honesty of advice. You go to Best Buy, and they will tell you that they are trusted advisors. They give advice. They tell you what's really good for them. But then it turns out they do not, you cannot sue them for breach of fiduciary duty. As a matter of fact, if you look in contract law, you can, there is a rule that says that if there is a relationship of trust and confidence, opinions have to be honest. But the examples given in contract law and by courts are doctors, brothers and sisters, priests, and so on, but not Best Buy. Yeah? Now, what is the problem with this? Well, what I say is that they should reveal their type. They don't have to give honest advice. If they honestly reveal that they give biased advice, that's fine. So if they say, we're going to give you advice, watch out, it can be biased advice because we're more concerned about markups. But if you still want to buy from us, that's fine, that's okay. But they cannot just pretend that they're one type, that they're the type who's really giving advice for what's good for you and do the other. So I say that the general principle of contract law suggests that whenever you say that you give honest advice, that basically you should be held to fiduciary standards. That would make a big difference, but it's a small step in the consistent application of a principle that's already in the law. And look at it from this perspective. I want to know if my search process is advice-based. I want to know who are the honest advisors and the dishonest. Now, who knows this better? Who is the least cost information gatherer? Do I have to figure out who's really honest? Is that my... Well, they know it better. Whether everybody knows from himself whether they are honest or not. So they are the least cost information gatherer. They should reveal that. So they should disclose their type and then be held to the type. So in general, look no further stories. Should be on the radar instead of under the radar of the legal systems. I think my time is up. Yeah, okay. Thank you, yeah.
Well, thank you, and I'm happy to continue this interesting panel on justice and contract avoidance. I'm going to continue a bit on what we've just heard. I mean, we've listened to Gerrit talking about problems with disclosure, right? Information asymmetries. We all know that we as consumers often underestimate what we're getting ourselves into when we're concluding contracts. I'm assuming most of you here are not European and not familiar with European laws, but we do have certain remedy for consumers entering into specifically distance selling contracts. And by distance selling contracts, I mean contracts concluded not face-to-face. So the whole of pre-contractual contact between the sellers and the consumers had to take place by means of distance selling communication. So that can be online contracts, contracts concluded by phone, fax, whatnot. But, and in these situations, we grant in Europe consumers the right of withdrawal. So the right of withdrawal is a mandatory right, which means that consumers cannot be cheated out of it. So sellers actually have to give it. It's guaranteed by laws in all European countries. And we have this right already for quite some time, but last year, or actually 2 years ago, we had a new directive that was adopted in the European Union, the Directive on Consumer Rights, which will enter into force this year, and it will introduce new rights of withdrawal. I mean, the whole situation will change a bit, and I'm going to explain a bit how this right of withdrawal works and what will change about it. But what I'm going to present you today, really, is the evaluation of the right of withdrawal. When I found out that the rules on the right of withdrawal will change in Europe, I started posing some questions to myself and then more openly to others in my article that I prepared, that I wrote. Namely, okay, so why exactly do we have this right of withdrawal, and is it necessary, and is it actually doing what it's supposed to be doing? The right of withdrawal is there to, well, it's a measure, paternalistic measure, to protect consumers, but the justifications that were used for introducing it in the first place in 1990s, well, they might not be still relevant and they might not still be there. So I wanted to see whether in these new revision of law, whether they took into account the justifications that were there, whether these justifications had changed, and how did they justify the revision of the right of withdrawal. And I did assess that from the behavioral law perspective. So I looked into, okay, so how consumers actually go through the process of withdrawing from a contract, what influences their decision-making, and what biases they might suffer from that might stop them from using right of withdrawal in an efficient way. And I tried to see whether these biases that are there, whether they actually prevent the effectiveness of the right of withdrawal and might go against the new rules that have been introduced. So the aim of my paper was to assess the mandatory right of withdrawal in distance selling contracts. I looked into happiness of consumers. Now, happiness of consumers is a bit of a tricky yardstick to use in a paper because it's not quite easily quantifiable, right? I mean, we have all these data that you can look into, like, you know, when people are happy and how to measure happiness, but that hasn't really been conducted yet as far as consumer contracts concerned. So I didn't actually have hard data to fall back on, but what I tried to do is to logically assume that, okay, if people would have feelings of regret due to some conclusion of a contract that didn't get them necessarily where they wanted to go, that would probably diminish their happiness as to conclusion of that contract, and that might prevent them from concluding similar contracts in the future and might undermine the whole effectiveness of the right of withdrawal. So I tried looking into that, and my research is descriptive. I didn't do any empirics myself yet. I'm kind of hoping I will be able to do it in the future. And my descriptive research so far allowed me to draw certain preliminary conclusions that lead to, that allow me to question the revision of the right of withdrawal and the new rules that are there. So, briefly, what is the right of withdrawal and how does it change? Currently, or up to this year, we had the right of withdrawal in these distance selling contracts that was 7 days long, 7 working days, which meant from the moment you received the goods, so not from the moment you concluded the contract, but from the moment you received the goods, you had 7 working days to make up your mind whether you want to withdraw from a contract. By withdraw from a contract, I mean that you can actually terminate the contract without having to give any reason for it, and you could do it in any form, really, in most jurisdictions. So you didn't even have to write a letter. It was often sufficient to just send the goods back, and that was seen as effective withdrawal from a contract, which meant that you had no obligations whatsoever under the contract anymore. You didn't have to pay any compensation for the use of the goods in the meantime before you withdrew from a contract, unless, and that was from the Court of Justice judgment, it was not clearly defined in the law, but the Court of Justice said that if the goods would be used contrary to good faith, then potentially you would have to pay certain compensation for the use of goods in the meantime. But it was, it's quite a recent judgment, and it's not quite clear when this compensation would have to be paid. If you weren't informed that you had a right of withdrawal, because that was one of the information that had to be disclosed, mandatory disclosure requirements, then the right of withdrawal was prolonged, and it was prolonged at least for 3 months from the moment you received the goods. It was assumed that since you didn't know you had a right of withdrawal, you wouldn't be able to effectively use it. So unless the seller would give you the information on the right of withdrawal, your right of withdrawal was longer. And in some jurisdictions, like for example in Germany, it never ended. So up to the moment you would get information on the right of withdrawal, you could still effectively withdraw from a contract. And we had cases where this happened like 2 years after conclusion of a contract, where someone bought a laptop, and that laptop 2 years later broke down, and the consumer actually wanted free repair of a laptop. The seller refused, and then the consumer realized, hey, I still have my right of withdrawal, so I'm just withdrawing from a contract. And the seller couldn't block that because that was the law in Germany. They claimed that compensation for the use of goods, though, in that case. Only charged to the consumer was the direct cost of returning the goods. So as I mentioned, no compensation. You only had to pay for posting the goods back, but you had to get back the whole price you paid together with the postage costs that the seller had for posting the goods to you. Reimbursement had to happen within 30 days, and there were no formal requirements. The new laws prolong the right of withdrawal. So as of this year, it will be 14 days that consumers will have to withdraw from a contract. And if they are not informed about the right of withdrawal, the right of withdrawal will be prolonged to 12 months, plus the 14 days for the right of withdrawal. But these are mandatory rules, and this is so-called maximum harmonization, which means that right now, in all European countries, these rules will have to apply the way they are in the directive, and the European countries cannot change these rules to be more protective towards consumers. So Germany, in the first case, prolonged these withdrawal from a contract, so gave consumers unlimited withdrawal period when they were not informed about the right of withdrawal. But right now, Germany will have to adopt these 12 months as a cutoff period, just like any other European country. And there will be compensation for the use of goods as long as the goods value is seen as diminished because of the use of the consumers of the goods. So if the seller proves, and it's the burden of proof is on the seller, if they manage to prove that during the withdrawal period, the consumer used the goods in a way that diminished the value of the goods, the seller will have to pay for this diminished value. We have no idea whatsoever how it's going to go down. Like, there is no way to estimate what's going to be the test for it. We have to wait for the first cases, and that's going to happen probably somewhere end of this year, maybe next year even. And that's going to be national cases, and it has to go to the Court of Justice, so that's going to take a few years. And there are some more like little requirements that I'm not going to go into. So this is the new regulation of the right of withdrawal, and the two main points are that it has been prolonged, so it's going to be 14 days. I should mention it's going to be 14 calendar days. So the difference actually is not that big. Between 7 working days, it's like a few days extra, but not that long. The biggest change is that there is this regulation of the compensation for diminished use. Now, when the right of withdrawal has been introduced to the European laws in the very first place, there were these 4 justifications used why it has been introduced. Because, I mean, it deviates from pacta sunt servanda principle, that if you enter into a contract, you know what you're doing, the contract should be upheld, and you should perform your obligations, and you should be able to get your rights. Now, the justifications, one of the justifications we've heard about, it's correcting information bias. Especially in distance selling contracts, you have no way to estimate the value of the goods because you never see the goods. So you might have a certain expectation as to them, but you have to rely on whatever you can find online, for example, or whatever you hear on the phone. And it's seen that you might not gather all the information that you would need in order to actually establish the value of the goods to you and whether you actually want to enter into that contract or not. The second, and actually quite important, reason for introducing the right of withdrawal is to introduce it as a cooling off period. So to let consumers get rid of all the hot emotions at the moment of the sale. This reason is more used for doorstep selling contracts, actually. But for distance selling contracts, it also applies to an extent that, you know, like you have often these hidden advertisements online, like subliminal somewhere. You go to one website and then on the banner, there are all these banners showing up. And you might not realize that you actually are being steered towards concluding a certain contract, and only when you switch off your computer, you think about what you've actually done. So in that respect, it can also be seen a bit as a cooling off period. Then there is the trust and confidence issue. You don't know the seller you're dealing with online often. That might be a person in another country, there are certain reviews online you might use, for example, to establish, okay, is this seller reliable or not? But again, there's no face-to-face contact, so it's a bit more difficult than in regular contracting. And then there's the efficiency rationale. In general, that kind of combines all these other three justifications. It's seen that right of withdrawal will increase efficiency of contracting because it will allow consumers to be better in decision making as to whether the goods they are buying are of a value to them, and are of a value to them for which they are actually paying in a contract. It's supposed to prevent this market of lemons situation where consumers would not be willing to pay higher prices for higher valued goods because they would not trust in the fact that these higher valued goods were actually the higher price goods were actually of a high value. So they would be willing to pay average prices, and the market would collapse, and the right of withdrawal is seen as one of the measures that can prevent that. All of these justifications lead to one conclusion. I mean, it's seen that if the right of withdrawal actually fulfills all these functions that I've mentioned, it's supposed to lead to the increased number of distance selling contracts. And this is seen as something very, very desirable in Europe, because we're trying to increase and improve our market, internal market. We have all these cross-border contracting, and that's the easiest to do, is to do it through distance selling contracts, especially with consumer contracts. So it's seen that consumers should be protected the same way in all the European markets, and they should know what they expect, but also they should be encouraged to actually go beyond just buying from their own domestic sellers and try to, if you live in Spain, buy an iPad from Germany or Poland or another country. Of course, this right of withdrawal might allow that to an extent, but it doesn't take into account all the practical barriers to buying from a different country, like language barriers, which we still have quite significant, and which are quite significant, or like even the postage. Even if it's possible to buy from another country, postage usually still will be more expensive, and you will still have to figure it out, especially if you know that you have the right of withdrawal. You also know that you will have to send the goods back if you don't like them, so you have to figure out how that would take place. So the right of withdrawal gives consumers time to assess the value of the goods. All right, so these are these four justifications, and I question most of them, to be honest, in my paper. I don't have really time to go into this because I want to focus more on my conclusions. But I'm just going to tell you briefly that, for example, while the right of withdrawal is supposed to allow consumers to recognize the value of the goods better, and it's supposed to correct that information, or to an extent correct that information bias, I still think that if a consumer doesn't invest time before conclusion of a contract into learning more about the goods, it's not so likely to me that they would invest the time and figure out these informations better after conclusion of a contract. Of course, they would receive the goods, and certain expectations might not be met, which can be then, right of withdrawal can then prevent the feelings of regret of consumers from concluding the contract. But I believe that still that process of learning the value of the goods is not quite remedied by the right of withdrawal, especially since it's a short period. If you would have to actually learn the value of the goods, for that reason, you should have a bit longer time, not to be pressured also into learning the value as fast as possible and making all sorts of mistakes while you're trying to figure it out. The problem with also correcting information bias is that it might the right of withdrawal might prevent consumers from gathering salient information before conclusion of a contract. Because if you know you have time to figure out whether you want the goods or not after conclusion of a contract, why would you try to actually be efficient in your contracting and not just order like 10 pair of jeans and then figure it out which ones fit you after you get all of them and then return the ones you don't. Lots of people actually start doing that in Europe. And another reason was that it would allow people to find out which party is reliable, but there are other methods to obtain trust. Also online, there are all these agencies that can give you a trust mark, and as I mentioned, there are all these review websites, and if that would be improved, because at that point, people also don't know how to approach these comparisons online and which ones are reliable, which ones are not. So if that aspect would be improved, maybe we wouldn't need the right of withdrawal to remedy that. So then after going through all the justifications we have now, I tried to look into behavioral biases that are often mentioned when people talk about contract conclusion. So what can prevent consumers from concluding a contract and what can make people conclude a contract? Now, I don't see in the literature these biases being often mentioned in trying to determine whether to end a contract, to terminate a contract, and especially not with when the right of withdrawal is concerned. And I think that these biases should be taken into account then, especially if right of withdrawal is supposed to be evaluated as an efficient and effective measure. So that's what I tried to do in my paper. And the first one, I'm just going to briefly mention a few of them. The first one I took into account was the loss aversion. So consumers are seen as trying to avoid losses, right? Losses weigh harder than gains to consumers. And that might prevent consumers from actually using the right of withdrawal when they receive the goods and they think that the cost of returning the goods will be higher to them than the loss of actually, than the gain they get, So if they would return the goods, they would have to pay for it, and they would have to go to all this trouble of going to the post office, and then they would have to find a good that would replace the good they already have, and that might they might see it as something that's, well, a huge obstacle. So why would why would they go to all this trouble and actually use the right of withdrawal when if they keep the goods, maybe it's not exactly what they expected and wanted, and maybe they could get something better, but the loss of returning the goods looms to them higher than actually the gain of choosing something that is better than what they already have. Now, this loss aversion, I think, is actually going to increase right now because we add this unknown element of potentially having to pay compensation for the deterioration of goods. So this new regulation actually will make consumers, I think, hesitate more whether to use the right of withdrawal. Because they, especially in the beginning, they will not know when the seller will ask them to pay for the diminished value of the goods. And that will prevent them, I think, from using the right of withdrawal. So the effect of the new directive will be that the increased cost of using the right of withdrawal will effectively or may effectively limit time to assess the goods value as well. Because if you know, okay, the more the goods value diminishes with time, and it does diminish with time, especially because sellers might claim that the longer the consumer had the goods, the more compensation they have to pay for the diminished value of the goods. So I think they will also try to estimate as fast as possible, do we want to keep these goods or not? And that might prevent the whole idea of the right of withdrawal as allowing consumers to estimate the proper value of the goods to them, because it will again make them hurry with their estimation of the value of the goods and will negatively influence the whole process. Another effect is the endowment effect that I took into account, and to briefly summarize it, the longer the cooling off period is, the stronger the endowment effect is. So you have the goods in your possession and you believe more and more with every day that these goods is actually, well, yours, so it's good because it's yours, and you don't want to give them up. Again, the prolongation of the right of withdrawal might act here against consumers' interests. I don't really have time to go into the other effects, but in general, I wanted to tell you that the other options, because right now we have this mandatory right of withdrawal, the other options that could be considered by the legislator and haven't even been considered. This wasn't even on the table. What was on the table was we have the right of withdrawal in this form. Do we want to change it, and how do we want to change it as to the length and the process of using it, but not as to whether we should change the whole form or whether we should reconsider having that right at all. What they could consider was, should we have statutory right of withdrawal at all? Because it could be left to the market. And I know that in the US, it is often left to the market, these decisions. I think it depends per state, from what I've heard, whether there is a right of withdrawal or not and how it's regulated. So we could leave it to the traders to introduce it. And it actually happens a lot in Europe also at the moment that the traders introduce the right of withdrawal in a better form than what's in the law. So for example, they give consumers like 30 days to withdraw from a contract, or they cover all the postage costs. And they often give you this right of withdrawal not only for distance selling contracts, but even if you conclude a contract in a store. That does happen. I'm not sure how it's going to be after the introduction of this new right of withdrawal, because as I mentioned, it's going to be maximum harmonization. So the national laws have to be all harmonized and all give consumers the same protection. So that might actually undermine also introduction of better laws for consumers, better rules for consumers by traders. And in general, the argument against leaving it to the market in Europe is that it will be inefficient, that some traders would do it, but some others wouldn't, and then the consumers that need that protection wouldn't get the protection in the end in all situations they require it. The other two options that I think actually could be on the table are to provide not the mandatory right of withdrawal, but a statutory right of withdrawal. So the traders would have to give the right of withdrawal, but it would be an opt-in or an opt-out system, which means that traders would have to offer the right of withdrawal to consumers. So every contract would have to come with a right of withdrawal option. And the consumer would be allowed a choice whether he wants to pay more for the goods and have the sort of insurance of the quality of the goods, and then get the right of withdrawal, or whether he would get maybe the goods cheaper, but without the right of withdrawal. And you could introduce it either as an opt-in or as an opt-out right, depending on what the tests would show, what's more effective. Because of course there are all these biases as to like whichever default you choose, that default stays chosen. So in that respect, probably the opt-out default is better. But this hasn't even been considered. So what I try to call for in my paper is that we should have more empirical research to actually estimate what is the usage of the right of withdrawal, because there have been a few data that I could see, especially from Germany, which show that not many consumers right now use the right of withdrawal. And if they use it, it's usually the same consumers who keep on using it. So there's actually the percentage of the right of withdrawal can be high, but then it's going to be a few people that actually use that right of withdrawal. So I think that there are practical obstacles that stop people from using the right of withdrawal, and I think some of them I mentioned in my paper. But we do need more research on that and to see whether we can make this right more efficient. So thank you. That's what I wanted to present.
It looks like we have about 10 minutes for questions. Does anybody have a question? Yes.
For the last speaker, Joasia, if you watch late-night American television, it's filled with infomercials, right. Constant wall-to-wall infomercials, and they're all selling crap. And they all tell you if you're not completely satisfied with this, you may return it in 30 days with no penalty. All you have to pay is shipping and handling. I mean, the idea that merchants would be reluctant to disclose a right to withdraw, it seems to me it's a marketing technique, and it's because of the last thing you said. It's because so few people who are dissatisfied actually return the goods. And so I was wondering whether that might kind of undermine the whole basic concept here, because the right of withdrawal is getting people to buy things they might not otherwise buy, even though they may turn out to be totally unsatisfactory.
Yeah, I think that's a good point, and there's problems with information disclosure. I mean, they are huge, and it's like this whole mountain that everyone tries to climb and tries to come up with solution, and it's still not there. I think that one of the reasons that so it's hard to argue that because I've seen so much publicity about the right of withdrawal in Europe. It's hard to imagine people still don't know that they have the right of withdrawal. But it is true, because if you ask actually questions about it, people don't usually know how it works and whether that applies. There are quite a few exceptions as to in which situations right of withdrawal applies. So, you can imagine all online contracts, you have the right of withdrawal, but that's not the case. If you book a hotel room, you're actually excluded from the protection of the right of withdrawal in most cases, unless the seller offers it voluntarily. So I can understand that there can be at least confusion among consumers when they can use it. And one of the reasons why we have the right of withdrawal is quite strictly observed is by the courts, is because they think that the sellers can protect themselves by revealing that information, because they can then limit the amount of time in which consumers can use it. So when sellers go to court, when consumers go to court after like years of using the goods and try to claim, hey, we want to withdraw from a contract because we haven't been informed, and the sellers say, but this is unfair because they had our goods for so long and they've been using it then without payment, the courts are very strict because they say, well, you could have protected yourself by giving the right of withdrawal at any time.
Yes.
First, to sit, and on the same point, we have later rights of withdrawal or right to refund. So in the Hilby Gateway, you accept the terms of the contract if you don't return after 30 days, but the warranty on that computer, I think I bought one at the same time. I think it was for 1 year for the warranty for defects. But on Babette, I don't think contract can do it. I think that this is a situation where you like criminal overcharging in the criminal prosecution context. The state holds all the cards. The prosecutors get up and they say, well, we're not doing anything wrong. We just charged him with murder too, and for a simple assault. And it's his problem if he wants to, he's free to try and resist that. The only possible response to that is by the public defender's office as a group getting back and saying, well, you can't do this, we're going to go on strike, we're going to take everything to trial. Except, like in your context, the public defender's office has clients. They can't, they have to represent the clients as individuals in one-off situations, similar to the regulated entities are not totally one-off situations, but they are, for each individual deal, is it really worth the cost of fighting the regulator? I don't know if this can be solved in contract law. You're absolutely right. It's totally unconscionability, duress, and public policy is a very strong argument, but it looks like it's more something that has to be addressed in legislatures.
I'm so glad you said that, because that's my conclusion too. That it's a bad fit. Even though we use this language and we exclude it for all sort of private contract reasons, it's a bad fit. It goes against the basis of contract. And I do think that something has to happen, even if it's small steps that, and as many FCC commissioners and others have recommended, at the very minimum, you can't ask for something that you don't have jurisdiction to ask for in a rulemaking proceeding. At a minimum, that is, if we want to use the word unconscionable in the private context, so all the judges are alerted to what we're talking about, great. But I do agree. I think it's going to have to come with a clear understanding. The FCC, I harp on one because I know it, but two, because they do have a very old statute, and it's under a public interest mandate. So there's a lot of malleability there, so that sometimes these things go forward. So I agree with you. Good.
Question for Gerrit. Are you suggesting that a purchaser no longer has a duty of reasonable diligence to discover matters that are readily ascertainable, checking the public records, for example, non-disclosure of zoning in a real estate contract, where a buyer, I've always thought and taught, that a buyer would have a duty, reasonable duty, to check the public records, or even taking it to the sale of goods. Does a buyer in today's world have a duty of diligence
Yeah,
to see whether it's been in an accident or in a flood.
Yeah, yeah. Buyers have that duty. So the least cost information gatherer means that sometimes the buyer has to do the work. Sometimes the work can be done.
Would those be two examples where the buyer would be
Well, yeah,
under
yeah, yeah.
your analysis,
Yeah,
the
yeah.
LCIG?
Exactly. The only, and that may be if the seller deliberately misleads, actually sets up a trap, then occasionally courts say, well, buyer, you had to discover the trap. But most courts say, no, if it was, and that's correct also, because if you think about it, who can avoid this misleading at least? Because actually, if the seller stops, they actually save money, because actually they spend money to mislead, and so if we say you stop, they even save money. So it's just an application of the least cost information gatherer, and in many cases, yeah, the buyer is responsible, and that may give the impression that sometimes caveat emptor rules, because sometimes the buyer loses, but it's not true. Actually, we look at who's in the best position to do it.
Any other questions? None? All right, well, let's go ahead and conclude, and my understanding is that the shuttles will be out front at 5:10, and it's the last one coming, so you don't want to miss it, okay? Thank you for coming. Thank you to our presenters. Thank you.